Hello everyone, welcome to Apurva's Legal Bites. Today's topic is anticipatory bail. So in this video, I'll let you know its meaning, history, purpose, section under CRPC and the differences between regular bail and anticipatory bail. So first, anticipatory bail means a bail in anticipation of arrest. The name itself suggests a bail granted to a person in anticipation and apprehending arrest. Now coming to the history, this term anticipatory bail was first mentioned in 41st Law Commission Report 1969, where the committee felt a need to include a provision for protecting an accused or any other person who is apprehending or having a belief that he or she may be arrested for any offence which is non-bailable in nature. So taking into consideration the said report and the grave need of the hour, Parliament has included a provision that is pre-arrest bail under section 438 of CRPC with this heading. And coming to its purpose, no person is confined in any way until and unless held guilty. Now coming to section 438 of CRPC. So first, subsection 1. When a person has a reason to believe that he may be arrested for a non-bailable offence, then he can apply either to the High Court or to the Court of Session for the anticipatory bail. And if the court thinks fit, it may direct that in the event of arrest, he shall be released on bail. Now, the factors like nature and gravity of the accusation, antecedents of the accused, means whether he has previously undergone any imprisonment for committing cognizable offence, or the possibility of the applicant to flee from justice, or when the accusation is made with the object of injuring or humiliating the applicant by arresting such person. So, the court, after taking into consideration all these factors, it may either reject the application or may issue an interim order for granting anticipatory bail. And remember, if the High Court or the Court of Session has rejected the application or has not passed an interim order, then the officer in charge of a police station may arrest the applicant without any warrant. Now, subsection 1A. This says that when the court grants an interim order, then it shall issue a notice not less than 7 days to the public prosecutor and to the superintendent of police along with a copy of the order. Here, the reason for giving this notice and the copy of order is to give reasonable opportunity to the prosecutor to defend the said application before it shall be finally heard by the court. Now, subsection 1B. This says that when a public prosecutor makes an application before the court, when the anticipatory bail is pending, then the presence of applicant is necessary during the final hearing of the application and at the time of passing the final order. And here, the applicant presence is obligatory when the court considers that such presence is necessary in the interest of justice. Now, subsection 2. This says that when the court grants interim protection to the applicant, it can put certain conditions upon him, like he should be available himself for the interrogation which is to be conducted by the police officer as and when required, and he should not leave India without the permission of the court, and he should not make any inducement, threat or promise either directly or indirectly to any person who is acquainted with the facts of the case in order to dissuade him from disclosing such facts either to the police officer or to the court as the case may be. Now, subsection 3. If the application is allowed and if a person is arrested without warrant by an officer in charge of PS, then he shall be released on bail immediately. In case if the magistrate takes a cognizance of such offence and issues a warrant against such person, then such warrant shall be a bailable warrant. And last, subsection 4. This says that this section will not apply to a person who is arrested for committing the offences under these sections. And these sections are nothing but they are related to rape under IPC. And last, coming to the differences, bail is a post-arrest legal process. Means the bail is granted after the arrest of a person. Whereas anticipatory bail is a pre-arrest legal process. Means the bail is granted before the person gets arrested or if the person has reasonable apprehension of arrest. And you all are aware that the offences are classified into bailable and non-bailable offences. So in bailable offences, bail is claimed as a matter of right. Whereas in non-bailable offences, it is claimed not a matter of right, but it is the discretion of the court. On the other hand, anticipatory bail, we can call it as some of extraordinary character, which must be used by the court sparingly after considering the facts and circumstances of the case and the nature and the gravity of the alleged offense. This is the end of the topic. To know the law in a simplified way, don't forget to subscribe to my channel Apurva's Legal Bites.